Hi everybody, Attorney Richard Seller here. April 2019, wanted to talk today about a recent Supreme Court ruling which is going to make the use of what's called alternate dispute resolution or arbitration agreements more prevalent in employment situations. So let me explain to you what it means. First of all, employers in this country can make employees sign an agreement as a condition of coming to work that says they're not allowed to go to court, that they have to go before what's called a private arbitrator or into an arbitration, where a judge that your former employer pays for decides your case rather than a jury of the public. Now, it's not a great situation for an employee to be in, because remember, who's paying the judge to make a decision? It's your former employer. So the judge is going to want to have more work from them in the future. So they're more likely, in my opinion, to rule in favor of your employer, even if your case is solid. So from an employment law perspective, as an employment lawyer for employees, we generally do not want to be in arbitration. But what happens is, as the Supreme Court and courts are starting to enforce more and more of these arbitration provisions, which you sign and probably don't even read at the beginning of your employment, it's taking the employee's access to court, which is a fundamental right, away. And the courts seem to be really okay with doing this. So that's what the law is now. And now the Supreme Court has essentially killed any employee entitlement to class actions in court, because there's a recent Supreme Court decision from a couple days ago which essentially moves everything to arbitration and says that all class actions, if the employee signs off, have to go to arbitration rather than in front of a judge that's appointed by the public or the president. And it's not a great situation. So employers, what you're going to see over the next year or so, we think they're going to start rolling out arbitration agreements in the workplace, where anytime somebody comes to work for the employer, they have to sign something that says, I agree that if I'm discriminated against or not paid properly, my claims can't go to court, they're going to go to arbitration instead. And I'm agreeing that I can't be part of a class action, I can only fight for my own rights. So it's a terrible decision. Arbitration is generally not where employees want to be for the reasons I've stated. As an employment lawyer, there are some upsides in terms of requiring the arbitration process to move forward. The upside is, one, it puts a lot of pressure on the employer because they have to pay all of the arbitrator fees, and that could be $30,000 to $50,000 to just pay the judge to ultimately decide the case. I talked about why that could be bad too. Also, the case will move more quickly in arbitration than it does in court because the arbitrator is really going to move the deadlines along. So that's another benefit too. Another benefit is the parties are required to mutually agree upon who the arbitrator is going to be. So it's not just like the employer says, this is my brother-in-law, Johnny, he's the judge of your case. Both parties have to submit lists to see if we can agree upon an arbitrator. So there is at least hopefully some balance in the process. Again, the downsides of arbitration, that guy's deciding your case. There's no right of appeal. There's no jury of your peers. So it's a mixed bag, but the bag ultimately falls in favor of the employer. This Supreme Court decision is a tough one. And I think employers are going to seize on it. From our perspective, final thought, if I've got to go fight for your claims in arbitration, then I'm going to go to arbitration. That doesn't mean that we're going to stop pursuing your claims, or it's just one extra hurdle that's not preferable, but is not the death knell of, fighting for your rights and you prevailing on your claims. So arbitration thoughts on a rainy Friday here in April. Hope everybody has a great weekend. Stay safe. And of course, if you ever need us, Richard at FloridaOvertimeLawyer.com, or visit us at www.FloridaOvertimeLawyer.com. Always happy to provide free advice. Always happy to answer your emails. Stay safe.